To tackle this topic, I will divide my presentation into two general chapters. We will be talking about the judicial remedies first, and afterwards we will be talking about the so-called voluntary schemes, an alternative to the traditional judicial remedies. When we come to judicial remedies, we are talking of the remedies, those remedies envisaged in the CRIPS agreement adapted to the online environment. So many of these remedies are well known to in any jurisdiction. We have disclosure, recovering and preserving evidence, preventing removal of assets, damages, and injunctions. Disclosure of documents and information is foreseen in Article 43 of the CRIPS and Article 47 of the same agreement. Article 43 refers to the power on the claimant to provoke a judicial order to the other party to produce evidence by the other party, provided that some requisites are met. So, first, the party interested in the other party, in the opposing party, producing a specific evidence, has to present reasonably available evidence sufficient to support his claim, and this interested party has to specify evidence relevant to substantiation of its claims, which lies in the control of the opposing party. A very important issue here is the protection of confidential information. So all of this is subject to the condition that measures or additional conditions are met to ensure the protection of such confidential information. Article 47 of CRIPS refers to a different issue. This is the so-called, at least in the framework of the enforcement directive of the European Union, and also in the framework of the CRIPS, the right of information. This is another address to the infringer in order to inform the right holder of the identity of third persons and also channels of distributions. Here, the CRIPS agreement refers to a specific condition by saying that members may provide the judicial authorities with these powers unless this would be out of proportion to the seriousness of the infringement. Second remedy relates to the recovering and preserving evidence. And here we have to mention Article 50 of the CRIPS agreement under the heading of provisional measures. According to this provision, the judicial authorities shall have the authority to order prompt and effective provisional measures to preserve relevant evidence in regard to the alleged infringement. The fourth remedy we can refer to is preventing removal of assets. And here we are mentioning the enforcement directive. This is outside the framework of the CRIPS agreement. According to this provision, the precautionary seizure of the properties of the alleged infringer, including the blocking of his or her bank accounts, may be ordered by judicial authorities, provided that we are talking of an infringement committed on a commercial scale. This is very important. And that the injured party demonstrates circumstances likely to endanger the recovery of damages. Now we are entering into the traditional field, the traditional remedies for the enforcement of IP rights. We are talking of damages. Uh, Article 45 of the TRIPS agreement, according to which the judicial authorities shall have the authority to order the infringer to pay the right holder damages adequate to compensate for the injury suffered. Here, a number of issues arise. Mm, So, first, the concept, the definition, and the interpretation of the concept adequacy. This is one of the maybe this is one of the um, more difficult issues when trying a case on IP rights. Therefore, the question of the existence or not non-existence of a scheme for calculating damages. This is the case in the European Union with Article 13 of the Enforcement Directive. In brief, this provision envisages a twofold damages calculation scheme at the choice of the injured party. Therefore, the right holder can opt for a compensation composed or taking into consideration or calculated taking into consideration all negative economic consequences, including right holders, lost profits, and unfair profits made by the infringer. But we have to make it clear that these two terms are non-cumulative. And as an alternative to this system, the so-called notional license. This is at least the price, the royalty that the infringer um, should have paid in case he had obtained a license from the right holder. Another issue here is the question of statutory damages. If statutory damages are envisaged in the corresponding legislation, this makes our life, and I am referring by our life, the life of judges, much easier. And finally, the issue of punitive damages. This this concept and this institution doesn't exist in every jurisdiction. For example, this is the case in the European Union. We don't have punitive damages. The characteristic remedy against infringements in the field of IP rights, more and more, is the so-called injunctions. This is the order, the judicial order to a party to cease from an infringement. This is foreseen in Article 44 of the TRIPS agreement, and it is also envisaged in Article 11 of the Enforcement Directive. That transposes these provisions to the European Union. There are, however, some specificities in the framework of the European Union, in the framework of this directive. I am referring to the fact that, according to this provision, injunctions are foreseen not only against infringers, but also against intermediaries. So we can read there the following. Member States shall also ensure that right holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe an intellectual property right. The second specificity is that there is possibility of a penalty in order to ensure compliance. Therefore, you can read in the Enforcement Directive that we are provided for by national law Non-compliance with an injunction shall, where appropriate, be subject to recurring penalty payment with a view to ensuring compliance. And well, we have to refer here to something that it is not written in the enforcement directive, but does exist in this part of the wall. I am referring to the cross-border injunctions that are expressly admitted in some jurisdictions. Namely, the Netherlands was the first country expressly um, mm, issuing an order like this. It was the case Linko versus Interlas in 1989. Here, the Supreme Court of the Netherlands granted an injunction to restrain a Dutch company from infringing the claimant's trademarks, not simply in the Netherlands, but in all other countries in which the defendant carried on business. And lastly, also, we have renowned cases in the United Kingdom. I am sure that to this point, I haven't I haven't I haven't made you know so many new things, because this is probably something that you already know. But now we have to descend to another field. We have to recognize that the judicial remedies are not so effective to tackle online IP infringement. And therefore, the private actors, I mean the actors of the market, have developed their own schemes to tackle this problem. This is the issue I am going to refer to. Here, this part of the presentation is based in the reference document you can read there. This is a study prepared by Dr. Frederick Mostert and Ms. Jane Lambert for the WIPO, and there you can find the reference of the document in question. These voluntary schemes are an alternative to court procedures as a means to efficiently cope with the volume and velocity of online IP rights infringements. They are focused on internet services providers. This is on intermediaries. They are often based on some form of notice to the intermediary and are applied in accordance with statutory provisions or voluntary codes. They intend to be efficient. Nevertheless, here a warning is raised by many legislators and authors, because while one or maybe the main objective of voluntary measures is to increase the effectiveness of IP rights enforcement online, it is important to strike a fair balance between the rights of all those involved in these procedures. That is, not only right holders, but also users of internet services and competitors. Here, fundamental rights like freedom of expression, access to information, privacy, data protection, lawful competition adds to the right of property or intellectual property rights. There are several techniques or several techniques that can be put under this umbrella. Now we are going to refer to some of these. The first we can refer to is the so-called notice and takedown systems. These systems implies that the ISPs must remove, are obliged to remove infringing content online upon notice by the right holders. This is, for example, foreseen, or it can be seen in Article 14 of the e-commerce directive. Nevertheless, concerns may rise with regards to two main questions. First, effectiveness, because the what we have called whack-a-mole problem persists. In addition, there are concerns, or concerns are rise with regards to misuse, to abuse, because these mechanisms can be used by the right holders to uh, uh, to take down non-infringing content. There is a risk that non-infringing content are taken down. In addition, there is another factor that we have to take into consideration, because now many of these notice and take down procedures are automated. It is the case of the so-called robot takedowns. And this makes the concerns over the accuracy of the system even higher. The second scheme, or the second modality we are going to refer, is the so-called notice and stay down mechanisms. In these cases, the taking down is followed by monitoring of the platform with a view to identify any reoccurrence of the infringing content and block it again. This is foreseen, for example, in Article 17 of the Copyright in the Digital Single Market Directive, that we will refer to in a more extensive way later on. Another system in the same line is the so-called notice and notice system. It consists in forwarding notices of suspected infringements by ESPs to account holders. Well, this system has a name primarily educational, in the sense that no contractual or judicial consequence necessarily flows from these notices. One of the most successful systems in this field is the filtering and monitoring. Very briefly speaking, this system consists of filtering and monitoring the website for illegal content by tracing and matching digital fingerprinting or unique identifying hashes. The fact is that these systems require significant financial and IT resources. So, although they can be considered as the new normal for the big tech players like YouTube, it is not. These systems are not easily accessible to startups or SMEs. We will consider here, or I think it is good to consider here the case of the European Union, because in this framework we could identify a situation in principle conflicting, because of the e-commerce directive dated 2000 and the copyright in the digital single market directive dated 2019. Article 15 of the e-commerce directive establish that no general obligation on ISPs or can be imposed on ISPs to monitor the information transmitted or stored. or to actively seek facts or circumstances indicating illegal activity. The ruling in the copyright in the Digital Single Market Directive is quite different. Here, the so-called online content sharing service providers first have to show that they have made best efforts to obtain a license or authorization from the copyright holder, and in cases where such authorization is not obtained, to filter up and preemptively block specific works on which the copyright holders have provided the relevant and necessary information, such as digital fingerprints or ID hashes. In addition, service providers have to maintain effective notice and take down and notice and stay down mechanisms based on the information provided by copyright holders, and must provide for effective and expeditious complaint and redress mechanisms. As you can see, in principle, there is a contradiction in the provisions of this directive and the e-commerce directive. But as instead of conflicting laws, I would talk of specialized law. Therefore, European Union has a horizontal approach, whereas the directive of 2019 refers to copyright. This is lex specialis as regards the general law, the general regime foreseen in the e-commerce directive. Another very important system in this field is the blocking. It involves ISPs disabling access to websites distributing infringing material. It can be implemented by way of a court order. In this case, we could talk of a traditional injunction at the request of the right holder, but this blocking can be also be implemented by ISPs of their own accord or on request from a right holder within the framework of a voluntary scheme. In the framework of the European Union, some member states, and this is the case of my country, Spain, have developed an administrative system where the judicial authority keeps an initiating or supervisory role. Another system is the so-called pre-clearance system. It means that protected material needs to be pre-cleared and licensed before this material is uploaded to user-generated content platforms. And finally, we have to refer to those soft law schemes that now are knowing, let's say, a kind of golden age in some parts of the world. And here, the best thing I consider I could do is to put you an example. This is extracted from this report we have referred to earlier to the President of the United States. And there you can read a number of best practices that are recommended by the authors of this report.